The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your mostly bi-weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by IJ Senior Attorney Jeffrey Thomas Rose and IJ Research Attorney Ricard Poch-Kanawala. We'll start things off in Jeff's adopted state of Texas, where in addition to his duties at IJ, he is an adjunct professor of law at the University of Texas in Austin. Jeff, what is the class that you teach about?
Yeah, so this is a fun class called Strategic Constitutional Law. And what I'm trying to teach the students is how constitutional lawyers actually litigate cases. So in addition to studying some constitutional doctrine, we look at the big cases and talk about how the lawyers litigated them carefully and the decisions and judgment calls they made along the way in order to propel them from the trial court all the way to the Supreme Court. And students really seem to like looking at constitutional cases from the practical lawyer's point of view.
Where did you get the idea for the course?
Actually, it was originally part of a former director of the Center for Judicial Engagement here at IJ, who was doing it at Clark Neely, who was doing it at UT, and then I took over.
Okay, Ricard, let's start things off in Texas.
So this case, Mosley versus Texas Health and Human Services Commission, is a decision from the Texas Court of Appeal. It's the procedural posture is that there's now a pending writ of review to the Texas Supreme Court appealing this decision. The plaintiff, Mosley here, worked as a group home resident aide, so she was taking care of people at group homes. There was an investigation by the State Department of Family Services as to her alleged neglect regarding a resident that she was taking care of. And this was alleged to be reportable conduct. Now, reportable conduct is super important in this context because what it means is you get put on what's essentially a blacklist, an employee misconduct registry, where any facility in the state of Texas has to go and check if a prospective employee is on that list, and if they are, then the facility is banned as a matter of law from hiring them.
Okay, the nutshell here is that the way she took her appeal was incorrect according to the statute, but it was correct according to the regulations that the agency itself had promulgated. And indeed, she took exactly the instructions that the administrative law judge in her case told her to do. And so the question in this case is, if the government actually tells you to do something and its regulations are on the books that you should do that, and then you actually do it, but the government turned out to be wrong, and there's a statute saying that you had to appeal another way, are you finished? Do the courts no longer have jurisdiction to hear your case because you didn't appeal the right way?
And what was the decision?
The decision at the Texas Court of Appeal is the government wins in this case. As surprising as it sounds, given the nutshell we just heard from Jeff, that's what the court finds. You can raise a number of questions with the decision. One, I'll pick on just one, and that is, it seems like the court actually mischaracterizes one of the arguments of the appellant, and that is the court says that just because you're bringing a constitutional claim doesn't relieve you of having to go through the jurisdictional prerequisite. But that's not actually her argument here. Her argument, as Jeff just laid out, is that if the regulations say one thing and I am actually told by the government to follow this, and I do, then it would be a violation of my constitutional rights of due process for the government to then tell me and the court to find that I'm out of a remedy, that I'm out of being able to bring judicial review.
Right. I mean, think of it this way. Somebody says, come to a job interview on Wednesday morning at 9 a.m. And then you show up on Wednesday morning at 9 a.m. and they say, oh, actually, I meant to write 9 a.m. yesterday. You didn't show up. We're not going to hire you. Goodbye. And that's basically what this lady is facing.
So what's the next step?
So the next step for her is that she has a petition for review pending with the Texas Supreme Court. And the main issue she raises is the due process issue. When the government affirmatively tells you to do something and a administrative law judge affirmatively tells you to do something and you do it, but everybody is wrong, can you be held accountable? And the sort of wider question here is what does it mean anymore to be on notice of what the law is? There's this ancient maxim that says ignorance of the law is no defense. And that's basically the position of the state of Texas. Look, if you had read the statute instead of the rules and instead of listening to the administrative law judge, you would have known how to appeal this. And there was a time when crimes were obvious and intuitive. Don't kill people. Don't beat them up. Don't steal their stuff. And so the maxim ignorance of the law is no defense made sense then. But if you look at the federal government today, for example, there are at least 20,000 laws. Nobody knows actually the number. And there are about 185,000 pages of federal regulations interpreting those laws, and each one of those regulations independently has its own force of law. So in 2018, how can we be charged with knowing, as lay people, all of the law, particularly something technical like a jurisdictional appeal requirement? It's ludicrous, and procedural due process requires the government to do much more now to tell people what they should do.
One other point in addition to that, the court here also says that the fact that the regulation, that she followed the regulation is irrelevant because another statute said that she had to ask for a rehearing before the agency. And the court says, well, there's no ambiguity here because the other statute told you what to do, so it doesn't matter what the regulation says. But if the regulation provided a certain appeal route, she followed that, and the government on top of that explicitly told her to follow that appeal route, how can the court say, as a matter of law, that there's no ambiguity there? I think your expression right there, John, shows that there's ambiguity there. So at the very least, the court should look into that and say that the Texas Supreme Court should look at that and say, well, then there has to be some ambiguity here because not only is the regulation saying one thing, but that the government understood their own regulation to be saying exactly what the appellant did. So I would argue that this is absolutely a case where there's ambiguity in the statutory scheme and the way statutes and regulations fit together.
Do you think this case is kind of a one-off? It seems like kind of an arcane thing, but maybe it's not arcane.
It's not a one-off because the laws are just too technical. And remember, the lady here is a low-income home health aide. She was accused of doing something wrong caring for someone, and if she was blacklisted, she would never be able to be a home health aide again. Now, she tried to represent herself. She doesn't have very much money. She can't afford to pay a lawyer, hundreds of dollars an hour in order to just get an order from a court saying that she's allowed to work. And under those circumstances in which lay people have to represent themselves, requiring them to know all of these technical, abstruse legal rules is likely a violation of procedural due process. And so the implications of this case, I think, are wider. This is the most egregious instance of this kind of notice problem, but it recurs in small ways everywhere.
Procedural due process is from the 14th Amendment of the U.S. Constitution, but this is a state case. Can you kind of explain the dynamics of that, Ricard?
Well, the 14th Amendment applies, and the Due Process Clause in particular applies to the states. So the states have to abide by a flaw. Now, I think a lot of people sometimes get a little confused on this. The federal Constitution in the 14th Amendment applies a flaw to which states cannot fall below in providing due process to United States citizens, but the states can certainly provide protections, procedural protections, and substantive protections above that.
Okay, let's move on to the next case. Jeff.
So this is a case out of Mississippi in which there was an undocumented Mexican immigrant, and he had a family, he had a life here. His children were American citizens. And he'd sought forbearance from Immigration and Customs Enforcement so that he wouldn't be deported. He otherwise qualified in terms of character. but he had not been continuously present in the United States. I think he'd gone back and forth to Mexico.
So he's a long-time resident of this country. The decision says that he's like a valued member of his community. His children are American. I think his wife is American. He's a law-abiding, tax-paying guy. He just didn't come here legally.
Correct. And so anyway, long story short, in 2017, Immigration and Customs Enforcement says they sent him a letter on May 31st saying, you got to be out of the country by tomorrow. And so his children bring a set of constitutional claims, equal protection and due process, saying that they'll be denied familial association with their father if he's suddenly deported, and also that the Immigration and Customs Enforcement just kind of randomly picks and chooses who it's going to enforce against. And so that kind of arbitrary selective enforcement was an independent constitutional violation. So the trial court said, oops, sorry, we don't have jurisdiction over this because you're not following the specific procedure administratively wading into the federal bureaucracy to contest an immigration ruling. So they appeal to the Fifth Circuit, and the Fifth Circuit says, yes, the lower court was right, that in matters to do with immigration, there is a very specific process. You have to wend through that process. And that's true even if all you are bringing are federal constitutional claims. Simply because your claims relate, because your constitutional claims relate to immigration, you are stuck in the immigration legal process. And this case raises an interesting issue, which is Congress has deprived the federal courts of their original jurisdiction over constitutional claims that are related to immigration. And, there's sort of this low-grade debate that always persists whenever federal courts do something that politicians don't like on some controversial topic. There's a blip where people say, well, maybe Congress should just deprive the federal judiciary of the ability to hear these particular types of cases. And although there's not a complete denial in this case, because you can appeal to the federal courts eventually through the immigration process, you can't do it in the first instance. And so this is similar to the last case in the sense that there's a technical problem that has deprived the court of jurisdiction. And here, it appears to be stripping the courts of their ability to actually hear constitutional claims when the plaintiffs have them.
Ricard?
I'd make one quick point here. The Sixth Circuit at least takes a different view on part of this to the Fifth Circuit. And what they say is that if claims are brought by the undocumented person's children or spouse, then for a lack of familial association, then those aren't claims brought on behalf of the actual person themselves, the undocumented person, and that therefore the provision, the statutory provision that removes jurisdiction, doesn't apply to those claims. The Fifth Circuit disagrees with that and says that is not the law, at least as it applies in the Fifth Circuit. So I think you've got at least the beginnings of maybe a circuit split on that narrow issue. But yes, in general, that does seem to be what the courts have found.
So the proper way for the daughters to have gotten their constitutional claims before a court was first to go through the administrative process. Is that even possible? Can the children of an immigrant who's going to be removed bring claims in an immigration court?
The Fifth Circuit ruled technically yes, because the claims, even though they belong to the children, are on behalf of and organically connected to the father. The claims don't exist but for the immigration enforcement against the father, and therefore they are fundamentally on behalf of the father. That's what the Fifth Circuit ruled. It's entirely possible that they will get into the immigration administrative process, and the United States government will take the position that these claims are not appropriate there because they are claims of American citizens, putting them in a catch-22, because the Fifth Circuit will have already ruled that they can't bring those claims in federal court.
I was also thinking, reading this case, it reminded me of other analogous claims that are brought in civil litigation by someone who has been injured as a result of someone else's tort conduct. Those claims are actually brought by loss of familial association, companionship, affection, are brought by not just in the name of, but actually by the relatives of the person. So there is analogous law that you could look to try and make an argument that that while the factual basis is related to the removal of the undocumented person, the actual legal basis for the claims are independent.
Okay, Jeff, let's move to the D.C. Circuit now for the next case.
Sure. So this is an interesting case that raises the question of when does a war end? And it involves a Yemeni citizen, Mr. al-Alwi. In 2001, after the September 11th attacks, he was sitting there thinking, gee, I could continue just sort of working and doing my thing. Or, what'd be amazing is if I went to Afghanistan and started shooting at Americans. So he decided to make that journey like thousands of other people. And he wound up getting caught in December of 2001. He was captured by American forces and pursued
Pakistani forces, I think, and then turned over to Americans.
Right. And so then under the congressional authorization for the use of military force, which Congress enacted on September 18th, 2001, al-Alwi was detained as an enemy combatant at Guantanamo in Cuba. So in 2005, he actually brought an action to get released. And that was turned down. And he's now trying again. And his argument is that by the time we roll along here to 2018, the situation in Afghanistan has so fundamentally changed that the war that Congress authorized and the war for which I was detained doesn't really exist anymore. Maybe something's going on in Afghanistan. Sure, there are some U.S. forces there, but there's now an Afghani government, and the U.S. forces are there in an advisory capacity. So we would like you, the federal court, to declare the war over, and therefore I can be sprung from my cell in Guantanamo Bay after almost 17 years.
The D.C. Circuit essentially says, and I think rightly says, no. First off, no, the war is not over. There is evidence in the record to show that there is ongoing conflict, that American forces are still in Afghanistan and still fighting remnants of the Taliban and Al-Qaeda over there. So the same conflict is going on in one form or another. The fact that the military operation may be under a different name doesn't change that fact, and nor does just the length of time, because that's the other argument that's made, that given the length of time that's passed since 2001 and the original authorization for the use of military force, that it's a different conflict now, and so that the authorization for the initial conflict has expired, and the court says no to that too.
Yeah, and I think actually the thrust of the decision is that it wouldn't matter if things ended in Afghanistan. What Congress authorized the use of force for was what the Bush administration ultimately characterized as the global war on terrorism, and so this is an ongoing conflict with an amorphous enemy that is diffused around the world in various groups and secretive cells. And I suspect that if everything became peaceful in Afghanistan tomorrow and Mr. al-Alwi went back to the D.C. Circuit, the U.S. government would say, we're still fighting the war on terror, and we don't see it coming to an end anytime soon.
And I think there's something to that, because that same authorization for the use of military force has been has justified force well beyond Afghanistan since 2001. So this really is a case that falls pretty squarely in what the congressional authorization was intended. I think you could make arguments in other cases about kind of as Jeff was saying, that this is a broad conflict that has incidents that take place elsewhere. So I think there have been questions as to whether this use of force authorization can apply in other instances. The Libyan example is one of them. But I think in this particular case, this falls pretty squarely as to what Congress authorized, and the fact that both under domestic as well as international law, the length of conflict doesn't change the fact that that a combatant is still part of that and held pursuant to that authority.
Yeah, Jeff, you mentioned that he's suspected of having shot at Americans, but he hasn't been charged with that, and it's been over 15 years at this point. Does that give you any pause at all, or can Congress just pass a law saying, you know what, extrajudicial detainment, it's fine?
So certainly under the law, under the D.C. Circuit's ruling, that's all it takes. One of the principles that this case illustrates that ties it in with the case we just talked about on the immigration issue with the father is that courts are exceptionally deferential in foreign affairs issues, so war in particular. The federal courts will not say a war is over. If the U.S. government, if the administration is saying that a war is still going on, it's almost certain that the courts will agree and would not grant a habeas petition like what Mr. Alwi has. Similarly, in immigration context, deference is at its maximum. So, as part of the Center for Judicial Engagement, we like to talk about how judges approach cases. Those dealing with foreign affairs get maximum deference.
Properly?
I think in questions like declaring war and conducting war, it is probably highly impractical for people to be suing and saying this particular battle plan that's being executed in Iraq as we speak is wrong for various reasons, and so I want a temporary restraining order against the commanding general. I just don't think that that's how things have ever worked in history, and no court in the United States would say that that's how they should work now. It's different in the immigration context. Perhaps there should be more engagement in the immigration context.
One interesting point in the case is that the court mentions that they would leave it to the political branches, kind of as Jeff just mentioned, to declare when a war is over. If it got to the case where the federal government had not declared a war over as a pretext for using other authority, to use the authority granted by a declaration of war, then that could be a different case. But we're nowhere near that in this case and in these circumstances, so that doesn't arise, and that would be a thorny question for another day. I think that's right about the foreign policy and particularly conduct of war, declaration of the end of war. I'd also echo what Jeff said. I think in the immigration context, we at IJ and in the context of judicial engagement, press for judges to really engage with both the Constitution as well as with statutes and with the law. And I don't think that part of it should be any different in the immigration context. But again, if the actual statute removes jurisdiction, then that may be so.
Jeff, the example that you gave of courts exercising jurisdiction over kind of battle tactics in Iraq, it's not really the situation here. This is a guy who's saying, look, it's been almost 18 years now since I've been imprisoned. I haven't gotten a trial. Like, that just feels like sort of a different scenario, like maybe one that courts could wade into without creating some of the concerns you mentioned.
That's absolutely right, John. And so, the Supreme Court has said, 10 years ago that the base at Guantanamo Bay, Cuba, is not an extra-constitutional zone where the federal government can do whatever it wants to anybody. And no agency of the American government can build a cell somewhere and assert the authority to put somebody into that cell without trial and throw away the key. So there's no question that, the immediate urgency of battlefield decision-making isn't the kind of thing that judges are going to get involved in. But but this particular case about the Yemeni, it does raise problems because he's been there a long time. It has changed. The circumstances have changed. And because this global war on terror is not a war against a specific country that will come to a conclusion, but is instead a kind of war against a particular method of violence that it might go on for decades. And we can't just keep people detained indefinitely.
So it seems like the D.C. Circuit isn't really taking the Supreme Court's 2008 ruling as seriously as it could.
I think that's probably right. Or at least we should be very troubled by the fact that almost 17 years after this man was detained, that he remains in indefinite detention because the U.S. military is operating in the name of the war on terror. I mean, he might die in prison in that case without ever having had a trial. Okay, let's move on to the final case, Ricard, which comes out of the Ninth Circuit.
Yes. So this is Gordon versus Drape Creative. Gordon, the plaintiff, is the creator of, and you may remember this, a YouTube video some years ago about the exploits of a honey badger. Gordon was the creator and narrator of the video and repeated a couple of catchphrases that became very popular, including "Honey Badger don't care" and others along a similar vein. So this becomes a real internet sensation and social media sensation. He sells merchandise with the catchphrases and referencing the honey badger, including greeting cards with the phrase. There's conversations between Gordon and the defendants in this case, the defendant company, about a licensing agreement for the defendants to use the honey badger phrase as well as sell merchandise with it. No agreement is actually entered into. That's important. No licensing agreements entered into with the defendants. But ultimately, the defendants start selling their own birthday cards and other greeting cards with the catchphrases, as well as using the catchphrases as punchlines. So that's the main point of the defendant's greeting cards. So what happens here is Gordon sues under the Lanham Act for trademark infringement, that the defendants are using his intellectual property. The defendants bring a motion for summary judgment to dismiss the suit, and the trial court grants the motion, and now we're up on appeal in the Ninth Circuit. And the Ninth Circuit reverses and remands to send the case back to the district court to hold a jury trial on one particular question. And that question is whether the defendants here, in using the plaintiff's mark, actually added anything in terms of artistic expression or relevance to it, or was it simply copying the plaintiff's protectable intellectual property and therefore falling within the scope of the act. So that's the question. I would add one other thing. The Ninth Circuit seems pretty skeptical that they say that there's at least a triable issue here, and it really seems like there is, that the defendants aren't adding much else to the greeting cards other than the catchphrases that Gordon came up with, popularized, and commercialized too. So there seems to be something there. But the other question that arises is whether there's under the Rogers test, which is the test that the Ninth Circuit applies in cases like this, where there is protected speech, so greeting cards convey a message, and so they're protected under the First Amendment. And so the two prongs of that are, one, whether there's artistic relevance, and that's the question going to a jury. But the second is whether there is whether the defendant's work explicitly misleads consumers as to the source or content of what it is. Basically, whether the defendant's work misleads consumers thinking that it's Gordon's work. And I would suggest that there's at least, again, a tribal issue on that. If you've got, if the main aspect of the defendant's greeting card are a bunch of lead-up lines and then Gordon's catchphrase, that seems to be what they're really selling. And so you would think that there's at least some chance that would mislead a reasonable consumer into thinking it's Gordon's work.
Jeff, your thoughts?
Sure. So speech can be valuable. This case is about who gets to cash in when something's funny. And the Honey Badger video itself illustrates the principle here. And that is, this comedian Randall, his real name, last name is Gordon. Anyway, this comedian Randall takes a National Geographic video, a copyrighted work. So he takes someone else's intellectual property. He adds satirical narration in order to create an artistically fresh parody interpretation of these really staid, serious kind of nature videos. Everybody loves it. Wait, we're G-rated here, so we're not going to say all of his catchphrases. But everybody loves his Honey Badger don't care thing. He turns around and commercializes it like crazy. He realizes he's hit the jackpot. He's become internet famous. And he's doing all of this stuff. And so then the question is, these other guys want to cash in on it too. This is hilarious. This is funny. Everybody knows these phrases. And these other people want to make money off it. But the thing is all they did was take his catchphrase, didn't add anything to it, and they wanted to make money. That's it. And so in the collision between these free speech interests of both parties, the greeting card guys and this guy, the courts seem to justifiably say that if all you are doing is exploiting the intellectual property of another and not adding anything of your own, forget it. You don't get to cash in.
And so that's the difference between what defendants did and what Randall the comedian did, because he did take National Geographic videos, but he added kind of the funny laugh track narration.
Right. I would be astonished if he licensed that video from National Geographic or ever paid National Geographic a dime for everything that happened. Maybe that's true, but I suspect it's not true because what he was doing is making a parody of someone else's intellectual property, and that's always been protected because that has independent artistic value.
So we've brought up the First Amendment a couple times, and usually you think about the First Amendment being the government threatening to put someone in jail for something they say. Where's the First Amendment tie in here? Because it's just different parties trying to cash in on speech.
Well, you still have a statute that a party is employing to bring an action against another private party. So you are using the plaintiff here, Randall Gordon, is using the government to as an enforcement mechanism against another private party. So if that so there is a government context nexus to the situation through the Copyright Act, and again, I think that's proper. We want freedom of expression and protected activity to be allowed, but at the same time, that cannot be taken as just a carte blanche excuse to copy someone else's work simply for profit without adding anything to it.
I mean, I think the most straightforward way to think about it is a judge is a government employee. So if a judge says you can't say that, a government employee is told you can't say something. And this applies beyond copyright. This has fraud, defamation. There's all kinds of contexts in which private parties are bringing claims against each other that implicate free speech rights. And so judges have to be careful about issuing an order that's backed by government force that would prevent somebody from saying something.
Okay, that concludes the show. Thanks for listening, and be sure to tune in next time for more judicial engagement. Until then, this is John Ross from the Institute for Justice, proposing that you get engaged.